Introduction then. Hello, my name is Jason Carlson. I'm with the Supreme Court of Appeals. I want to welcome everybody who's able to join us, and I know there's going to be a few more join as we get started. Um, I wanted to give a reminder to everyone. The questions. It can be a little difficult in WebEx at times to ask questions and stuff, but the best way to do it, everyone should have a chat feature. If you use the chat feature and send it to everybody, and just type your question in there, I will be monitoring the chat and will relay the questions when appropriate to the judge so he can answer them either during the presentation or after his presentation. He has also indicated that if there are many questions or if there's some additional ones, he can stay on a little longer past our allotted time and answer those questions as needed. So at this time, I'm going to turn it over to Judge Jim Douglas, the family court judge here in Kanawha County, and he is going to present on the new 50-50 law. Judge Douglas, start whenever you're ready.
Thank you, Jason. Welcome to everyone. Hope that this will be an enjoyable presentation. What we're going to do, or if it's not enjoyable, at least to be informative, but what we're going to do is be talking about the new 50-50 law. It's also been referred to pejoratively as Senate Bill 463 that became effective on June 10 of 2022. And this is going to be a practical nuts and bolts particular presentation. I guess we can also be talking about the loopholes or how you rebut the 50-50 presumption. But with all that being said, let's go ahead and get started here. First of all, the very first thing you know, I'm sure some of you have encountered situations where there are people still living together, but they want to live in the same household, but they want to have an allocation, or if they're having a divorce, they're wanting to have an allocation of custodial time while they're still residing under the same roof. Under West Virginia Code, if you'll see right there in the PowerPoint 48-9-101 and subparagraph A, the 50-50 presumption is only available to people that are not living together. So that should be a threshold inquiry on any particular cases that you may have as an advocate, or that's a way of also defeating the application of the 50-50 law. All right. Thing I wanted to point out here too, that I'm going to be talking solely about the new 50-50 law as it appears in Article 9. So when I make references to like Section 206, it's to be presumed that everything is Chapter 48, Article 9. I'm only going to be talking about the last three digits. It's all, again, I repeat, under Chapter 48, Article 9. The child custody codification that West Virginia has had in 48-9-101 at SEEK had been basically in place since 2001. It had undergone some changes in 2018 and some small changes in 2020, a little bit more substantial change in 2021. But the big change was in 2022 when Senate Bill 463, also known as the 2022 Best Interest of the Child Act, was enacted and made passed, signed by the governor, and made effective, just a second here, made effective on June 10 of 2022. The object I'm going to try to do is, object this exercise, I'm going to try to give you some specific and substantive, substantial changes in Article 9. And whenever we talk about the rebuttable presumption, we're talking about the rebuttable presumption of the 50-50 custody. And I'm going to hope to provide you some means whereby, or to either effect or identify where it can be rebutted. And then I want to also give you all some insight on the experiences I've had since its effective date, and to maybe, if we have time, to give you some idea about my predictions, which are right now about as effective as trying to predict what the 6 numbers on the lottery is going to be. But at any rate, I will give you based on my experience, both as a judge and a family lawyer, divorce lawyer, what may be happening with this case. Anyway, next, a little history I think is in place, would be proper to place here. The dissolution and non-marital allocations have something like a cyclical metamorphosis in West Virginia. Prior to 1986, and I realize I'm probably one of the few people who was practicing then, there had just been a presumption the mother was get the child. That was it. And whatever visitation, that was the word that was used then, was allocated to the father. That it was as varied as the 55 circuit courts across the state of West Virginia. Then there was, starting 1986, supposedly gender blind primary caretaker role. Somebody was designated the primary caretaker. And then there was parenting time carved out after that was established. At that same time, that's when the child support based upon the Melson formula, if any of y'all can remember that, you can probably remember Gilligan's Island, the Rubik's Cube, and the Sears and Roebuck Christmas catalog. But the Melson formula was in place, and that wasn't changed until 1997. But then that equitable distribution of marital property started in 1986 as well. One of the reasons that the legislature had determined to go to the primary caretaker and supposedly, quote, gender blind allocation, both in divorces and just naked allocations between people that were not married, was the idea that we don't want the kids to be a bargaining chip in equitable distribution. I'm sure any of you all were practicing prior to 1986. You probably recognize, as the Supreme Court did in the case of David M. versus Margaret M. in 1989, that there were situations where, for instance, a husband might say, or it could go the other way, a mother might say to the husband, as long as you give me the Corvette and the boat and the RV and the home place, I won't fight you for custody of the kids. And that was leveraged negotiation, and it worked. And I think, sadly, you'll hear a little bit more about it later. We may be coming back to that in some respect. But also the history about the primary residential concept that has evolved somewhat with cases has turned around what has been classified, or it has revolved around the classification of parenting functions and caretaking functions. Caretaking functions are 48-1-210 of the code, and the parenting functions were found in 48-1-235.2. And a lot of times, just for the sake of simplicity, these things were classified as, well, the caretaking functions were the inside stuff, and the outside stuff were the parenting functions. Example, inside being doing the wash, preparing the meals, getting them up to go to school with the kids. And outside, it would be things that benefit the children, like earning the living, mowing the grass, changing light bulbs, painting the outside of the house. And those also fell into male, whether it was historical, accidental, anecdotal, or whatever, but it devolved into identifying the inside stuff, the inside 210 enumerations as being the female and the outside being the male. And then also there was a time period that you look back to determine in temporary hearings who should be the primary residential parent by comparison of 210 and 235.2 factors. And it was limited to 1 year. Well, that's still in place under 204. And then for the permanent parenting under 206, before the year of 2021, you look back, before the year of 2018, and then it was modified somewhat in 2021, you look back 2 years. And that ignored basically the caretaking functions and parenting functions in the permanent and the temporary for at most back to 2 years prior to the time of the filing of the divorce action. So that was unduly rigid, and there's also the changing the family dynamic that was not taken into consideration. Somebody's a breadwinner now, and they're not the breadwinner later. But it was still under the primary caretaking concept and the primary residential parent concept. It's supposed to be considered what was in the best interest of the children, and it would promote the stability of the children. And prior to 2022, most of that could be found in 48-9-210. There were some enumerations there about the definition of what the best interest of the child was, and stability seemed to be the overriding factor. Finally, with what was considered and notwithstanding what I deem to be the gender equalizing provisions that may have been left over from other statutory promulgations prior to 2022, there was certain things, I mean, like I said, that stabilized or maybe made equal the playing field in gender selection as to who was going to be the residential parent. And that was primarily found in 206C of the old code that was superseded both in 2018 and 2021 and 2022. And it had quite a bit of judicial discretion. Now with the 2022 Act, the judicial discretion is really, I think, in my opinion, pushed back to whenever you make a determination about the permanent parenting plan. And that 50-50 parenting presumption means going into the fight, whether it's allocation or a custody fight incidental to a divorce, there is a presumption that the parenting plan is to be on a 50-50 basis. And if that presumption is not going to be applied, then you have to specify, both as a judge or putting on as evidence as a practitioner, a litigator, or if you're acting pro se, the data or the evidence was why it should not be applied. And I'll be speaking in specifics about that in just a second. The idea here is that I guess we're in quest of finding a negative as to arriving at a final parenting plan. Now, coming back to the 2021 amendment to 206C, there was a fear that the caretaking function, since they were supposedly female, were giving the advantage in litigation to the mothers as opposed to the fathers. And some of that component in the legislature, that particular makeup of fathers, or I used to think of fathers that had an axe to grind, or the mad dads as they've been pejoratively referred to, they were successful in 2001 of having 206, which is the permanent parenting plan, modified to say basically that parenting functions are equal to caretaking functions of 210. 235.2 was equal. And that is still part of the definition, though, that you have to look at. Parenting functions include caretaking functions, but parenting functions are not to be relegated to a lesser consideration by a family court judge. All right. And then also the 2021 amendment forbade final hearings being conducted solely by proffer. Now, we can debate whether that's good or bad, but that was the state of the law, and that's still the state of the law. Now, let's move on just a little bit, and I'm going to tell you that parenting caretaking function here in just a little bit, when we get about the middle of the presentation, to me, assumes a greater significance. So let's move on. The best interest of the child, as I alluded to earlier, is really set forth in 48.9.102, subparagraph A, and it enumerates in the statute that you'll look at, even up to the current iteration of 2022, 8 factors. And some of these were already, in my opinion, gender neutralizing, but they added under 102A4 that best interest, again, is, quote, and which is rebuttably presumed to be equal 50-50 custodial allocation of the child. But it's interesting to note that the legislature did not amend any other part of the statute that says, well, you know, I think you can limit the 50-50 by this particular statute alone. Under A5, it says you have to take into consideration, both as a litigator and a family court judge, that the parent knows how to provide for the child's needs and in a conjunction, who place a high priority on doing so. Now, the legislature wasn't content on adding that little clause after subparagraph 4 of subsection A. They had to pass a whole new statute that was called 48.9.102A right after the 2, as you can see on the screen. It sets forth the standard about the rebuttable presumption. In other words, it sets a standard for rebutting that presumption. And that's a preponderance of the evidence. But as I'll point out here a little bit later, the legislature neglected to deal with certain aspects of other statutes that change the burden of proof. It can be credible evidence, it might not have anything, or it might be substantial proof. But anyway, at this point in time, under that particular statute, it says a preponderance of the evidence. Now, also within that statute, they put what I consider to be a limitation is yes, presumption 50-50. Yes, rebuttals have to be a preponderance of the evidence, but still on the bottom of that statute, it says it still has to be, it limits that application of presumption to be consistent with ensuring the child's welfare. Now, that reestablishes discretion on my part as a family court judge, in my opinion. But let's go on to the temporary parenting plan. I think this is where we're going to see some litigation in the future, and that's where the meat and probably the volume of litigation will be, at least in the initial phases of the implementation of the statute. First of all, any evidence on a temporary, and I'm talking only temporary, has to be by relevant evidence. Now, that's not new. What does that mean? That means we can't have hearsay. We can't have unformed statements or double hearsay. It has to be relevant evidence. And it has to be admissible evidence. In other words, to me, it can be relevant, but it has to be admissible with it. Can it be limited? Yes. The temporary parenting plan and the assignment of who gets what time periods with the child or parenting is now under limiting considerations under 48.9.209. All of us remember 209 limiting factors, and usually that had to do with domestic violence and crime as a limiting factor. And 203 is not new, but it just, I don't know, maybe possibly the legislature, and I'm just speculating here, thought that maybe some of these limiting factors might be might be better received and have better optics if they're considered considerations and not limiting factors. But again, also, there is a new provision that the 50-50 presumption going into a temporary parenting plan, like it is going into a permanent parenting plan, can be limited by evidence that otherwise warrant limitation. In other words, you can have evidence in there, and if you don't specifically come within one of the 209 limiting considerations, it still gives the court, gives the practitioner some argument fodder, and it gives the court that much needed discretion. But the temporary parenting plan is a little bit more involved than that. There's a new provision under subparagraph C of 203 that says a parenting plan shall be made upon evidence presented at the temporary hearing. Now, judges and litigators alike, and even pro se practitioners, if anybody signed on to this presentation, it's pro se, you can't let the temporary hearing become a final hearing in disguise with its intended consumption of irrelevant time and argument. What I usually do, and what I think practitioners should do, and I think judges should likewise employ, is saying, okay, I'm going to take proffers from the attorneys that are there, or if they're not there, you can take statements from the litigants. But I would still take, even if they have attorneys, statements from the litigants under oath, because then that's evidence. So you come within the 203 statute is you have evidence presented and you can have proffers, all right, under Roman numeral 4. Now, as you all know, there's now under subparagraph F of 203 that if somebody doesn't like they got a custody allocation less than 50-50, they have a right, God forgive the legislature, they have a right for an interlocutory appeal. In other words, all of y'all that went to school in WU College of Law or Washington Lee or some other law school, one of the things that's banged in your mind on the first appellate course that you get, and I mean it's indoctrinated onto you, is there should not be interlocutory appeals. There's writs of prohibition, extraordinary writs that may apply to a temporary order, but temporary orders are not appealable. We still have in place a statute, 48-5-514 of the code, that says that they're not appealable, temporary orders. Nobody touched it, up at the legislature. There's also Rule 15B, little b in parentheses, that says that temporary orders aren't appealable. there's also Rule 16 that says that I can do temporary hearings by proffer, even though we're told that you cannot do it solely by proffer. Now, here's what the problem is. I think that a very intrepid and I guess all-knowing, omniscient family court judge, but intrepid litigator or party could make the following argument with a great deal of credibility. We are told that when the Supreme Court passed the rules of appellate procedure, both for them and the ICA, the Intermediate Court of Appeals, that if there are any contrary statutes, like under 51-2A-1 et seq of the code, that a judicial rule supersedes a statute. Okay, there are a number of cases out there that say that very thing. State versus Arbaugh is one that comes to mind. I'm reading this, of course. Maynard versus Logan and State ex rel Workman versus Carmichael. A rule, a court-ordered rule, supersedes a statute. That's part of the separation of powers. So if the Supreme Court has not changed Rule 15b about temporary orders not being appealable, and they still have in place Rule 16, I'm talking about these two rules, the West Virginia Rules of Practice Procedure of Family Court, that have been in place basically since 2000, been modified somewhat, but those two rules are still in place. Now, someone could argue that those two rules, 15b and 16, negate a large part of the temporary parenting plans under 203 that the legislature said how it will be done in 2022. In other words, that could be a good counter to an interlocutory appeal or or building in an appealable issue in a temporary that later you might have to take up as part of the appeal that you may have in a decision you don't like to the Intermediate Court of Appeals. We all know, and I'm sure everybody here knows that for some pro se's that signed on for this webinar, you need to know the ICA has exclusive appellate jurisdiction, all family law matters except abuse, neglect, and adoptions. So that's where it goes to. If you don't like what the family court judge does, that's where it goes. Also, domestic violence cases go on appeal still yet to the circuit courts of the various counties in which the family courts set. Now, parties and the family court judge can amend a temporary order somewhere along the line, but it has to be in the best interest of the child, and that's not new. But then you need to know, too, that under this situation involving the interlocutory appeal, you can't hold up the rest of the case. That's in the statute. You have to go ahead with the rest of the case, irrespective of how long it takes the ICA to pass on a temporary parenting plan that was taken up on interlocutory appeal. Because most family court judges, most parties are going to take a position if a parenting plan's working and nobody has any real big problem or a problem that's not insurmountable, a temporary parenting plan, a lot of times it becomes the permanent parenting plan, but you can't do it if there's an interlocutory appeal. That's in the statute. That's one of the problems. But keep in mind what I was saying about Rule 16 and Rule 15b of the West Virginia Rules of Practice Procedure for Family Courts. Now, the temporary parenting plan criteria must be relevant evidence again, and it has to be parenting plan has to be in the best interest of the child. Okay, now there's also a look-see under 204A1, which is brand new, that there has to be a determination, and remember that the 12-year look-back period is still in place for temporaries. There's no look-back period on the permanent. But which parent's taking greater responsibility in the 12 months preceding the hearing and the filing, preceding the filing? Which one's done more of the parenting functions? That's in the statute, not the caretaking functions under 210, but the parenting functions in 235.2. That's under 204A1. It's brand new. But this can be limited. One of the limiting criteria is it will cause disruption to the child's emotional stability while the action is pending. Well, as long as it takes some appellate courts to handle on appeal, custodial arrangements, some of the kids sometimes turn 14, sometimes they turn 18 before it's determined. So that is a real limiting factor or a limiting consideration in my mind is the temporary parenting plan causing disruption to the child's emotional stability? So you have to adopt a plan that it provides the least disruption to the child's emotional stability. And that's in the statute, and that wasn't changed. Number B is, now here's, even though 20102 says that there should be a preponderance of the evidence, the temporary order can be limited or even denied access to the child upon the lower standard of credible evidence from 209A. And they might be also including another error code, but it does say credible evidence from 209. The limiting considerations, remember I talked about of 209, is that, is it a preponderance of the evidence? No, it says credible evidence. Everybody at a law degree knows that credible evidence is a lesser standard. All right. And also that can be limited or access denied, which is not new, by finding that it's necessary to facilitate the protection of the other party pending adjudication of the underlying facts under 9. Usually that'll derive out of domestic violence case. But again, 9204E inconsistently says that the standard to defeat or limit a 50-50 temporary order under 209 is a preponderance of the evidence, not 209A, but a preponderance of the evidence. Up here in the yellow coding where I had 209A, there should be a parenthesis out of that. That's an error I didn't catch, but you can follow the gist of it. So there is a contradiction here in what the standard is for a limitation on temporary parenting plan. Let me move on. I want to move on to the permanent parenting plan under 206. And I want to deal first with custodial responsibility. Now, not decision-making. Under 206, that's two separate things. Custodial responsibility and decision-making. 206 has been entirely rewritten. It used to be that 206 under the old code took up about two columns or more in the code book. And now it's barely about 3 paragraphs, I believe. But it says that a 50-50 can be avoided. This is under 206 now, not under 209, if it's harmful to the child or it is limited by 209 factors. Now, again, that's not new. But the point of it is that it's 206 on a permanent parenting plan says a 50-50 can be avoided if it's harmful to the child. Well, judges, a lot of arguments can be made by lawyers, and judges can fit a lot under that category, that heading. But it also says under 206 that you can't consider the previous temporary order unless the parties agree. Well, to me, the way around that is what they're trying to say, they're trying to prevent the family court judges and the parties from arguing through their lawyer. Well, let's use the temporary order, judge. It seems to be working pretty well. Or the judge says, well, I haven't heard any complaints. I haven't seen any contempts. Everybody seems to be happy with the temporary. What I can do with that? Go ahead with that. You don't say that as the judge, and you don't argue that specific thing as a litigator. I just suggest that you use and agree to or litigate about the previous factual findings and conclusions of law, and judges should make no reference to the temporary order at all. It happens to be the same facts and come up with the same conclusions, but you don't make a reference to the temporary order. That's the way, I think, to ensure it not being turned over on appeal, or to ensure that the viability of the order on appeal. Subparagraph C requires presentation of the evidence at the final hearing. Now, I think you need 2 things in the orders, and I think you order drafters, either whether you're a judge or whether you're litigators out there and you get assigned to draw the order. For God's sake, and the Supreme Court said this over and over, and I think it's a good admonition, is have a category that says finding of facts, center of the page, underline. And then you have conclusions of the law, underline. Put a few statutes under it, or what you're relying on, either for appellate purposes or to protect the family court decision on appeal. All right? But again, it requires presentation of the evidence, and there'll have to be something. There'll have to be some testimony taken from the parties at a minimum. Another thing to build into your orders, I'm talking about your permanent allocation of custodial responsibility in your permanent orders, parenting plans. If you're going to deviate from the 50-50, besides having findings, fact, conclusions of law and putting it in there, and having some type of evidence on the record and make reference to it in the order, but you also have a finding of credibility. Judges should do that without fail to protect the viability and the longevity of your order, protect it from the ICA, protect it from the Supreme Court, or you can have a credibility finding if you represent the party that's wanting to overturn it. But try to have a credibility finding in there somewhere. That will make a huge difference on appeal. Take my word for it. All right. Next, I'll get into 207, allocation of significant decision-making. Entirely different thing. Entirely. A lot of times people, I think I see a lot of litigators, they lump significant decision-making together with custodial responsibility. They can be split. Now, there is a limitation of the 50-50 presumption at either hearing due to the ability or inability of both parents to work together on behalf of the child and the existence of 209 limiting factors or considerations. That is new. But there's something different here about the 50-50 presumption when it comes to significant decision-making. If you don't hear anything else I have to say today, and if you happen to have the materials, if you want to read any particular thing, read this Roman numeral 7 and 48.9.207 allocation of significant decision-making and look at the statute. The 50-50 presumption is only triggered if each of the child's parents has been exercising a reasonable share of the parenting functions, or if it's not in the child's best interest under 209 as shown by preponderance of the evidence. Okay? This 207B language is new, and it's regarding the presumption and the proof only. Now, what could this cause a problem? Well, many of you know I had nearly 40 years being in the trenches, been on the bench going on in my 7th year. And we see a lot of these cases. Well, what happens under this, somebody that really reads the statute and take advantage of it? What happens if mom and dad agree that caretaking functions are 50-50? What if a court finds that the caretaking functions are 50-50? Then we get into litigation about the parenting functions. Now, since caretaking functions are still part of parenting function, yeah, I understand that by statutory definition. But if they're equal or been adjudged to be equal or been agreed to be equal, I'm talking about the caretaking functions, then that takes them off the board. So what's left, and y'all, I can hear all of you saying now, oh, that's hardly ever going to happen. Watch and see. Just watch and see. Then what happens, then you have a disagreement about the parenting functions, or you put on an entirely different case on the parenting functions that's separate, then the decision-making could go to the party that has had more of the parenting function. Custodial might be 50-50. Significant decision-making may not be. Well, what's significant decision-making? Well, whether or not there's going to be some dating with your child, whether or not they get a tattoo. I know those are far out, but the ones that are more likely is what religion are they going to follow? What school are they going to go to? Where are we going to live? Where are we going to move to if it's still within the state or it's still within the jurisdiction? It can come up. And I think that parenting function, because of having that trigger, you can have litigation, that trigger, whether each of the child's parents, it's triggered 50-50. If each of the child's parents have been exercising a reasonable share of the parenting functions. That means that I think that it's been parenting function legislatively exalted that started in 2021 over caretaking functions that is, I guess, solidified in 2022. So beware. That's all I can say. Now get back to 209, these limiting considerations. This has the most teeth, and this is what you got to rely on in litigation if you're trying to overcome the 50-50, whether you're a family court judge that you don't want to do a 50-50 for whatever reason may appear from the evidence, or subjective reasons, who knows, or objective reasons. But it has the most teeth to overcome the 50-50. Now, 209, I remember when it first came out in 2000, it had about 5 paragraphs. That's what it had. Now you can look at it and it's a good, well, with the annotations and everything closed, it's a good page and a half. And of course, it has a standard first part under subparagraph A, domestic violence, sexual offender, felonies, criminal, all those things we all usually know about on 209, okay, that apply to it. But it does have some other teeth to overcome that presumption or to counter it. And again, not to be overlooked is that in the previous iterations or editions of 209, credible information standard was approved for substantiation of 209 allegations. And they took that out. So I think they're trying to say, well, this has to be by the legislature. And again, they didn't cover it all. I showed you earlier where they left in their credible evidence, but I think that's where they take that out and they say, well, that means it's preponderance. No, it's not clear. But anyway, that part was removed. But if you look at 209, the things that have been added to it that have some substance, it has the previous factors of parental alienation obstruction. That was in the 2016 and 2021 amendments. But it also has, they've added some paragraphs B and C that have added a person regularly in the household. Remember, it used to be talking about like new husbands, new wives, or boyfriend, girlfriend, or whatever. But now it's gender neutral, person regularly in the household to the mix about a limiting consideration. Does that mean bad grandpa? Does that mean Aunt Tilly who hits the sauce pretty regularly? I don't know. But that is a supplement to subparagraph F. Now, subparagraph F under 209 has a lot of tools to overcome the presumption. Any family court judge, if they don't want to do 50-50, and if the legislature's listening, the Supreme Court's listening, that's the way I see it, and I make no apologies. It has a number of tools to overcome that presumption and fit that discretion, judicial discretion right in there. You have to read the statute and see what's in there. The child's medical condition. That's a big one. I had one here recently. I've given this presentation 2 times before. I had one recently where there was a lot of litigation on whether or not this child had to have a nebulizer of a certain concentration of the liquid inside the nebulizer, and whether or not the father could handle that as opposed to the mother who had been handling it, and whether or not there'd be the right composition of the liquid. I mean, we probably spent 15 minutes on that alone, but the child's medical condition, chronic illnesses, special needs, or other serious medical condition. Well, who's to say what's serious and which one can give more appropriate care under a different parenting plan other than the 50-50? Whether the child will be separated from siblings, I think that's a good one. We're talking about it, and the legislature didn't limit it to siblings of the full blood. So separation from siblings of the half blood is something that can overcome the presumption. A nursing child who receives substantial nutrition through nursing. Well, substantial, does that mean Similac? I don't know. My youngest is 38. I don't know whether Similac still exists or not, but formula, okay? And when you look at that, let me turn over to this. I was talking to you about this. There's a limitation on the nursing even. It's an automatic ground under 209, even though nursing may be a deviation from 50-50, overcoming the presumption. It dries up, pun intended, at 1 year. So they're saying they're not going to use nursing, or nursing's not going to be used, and some automatic ground for modification, really the way I read the statute. And then the other one that I think is going to really receive a lot of play under 209 limitations, subparagraph F, is whether or not the obligor parent has been in noncompliance regarding the payment of child support. Well, does that mean missing one payment? Does that mean being 6 behind? Does it mean being 10 behind? Well, is being out of work a grounds to that counters the noncompliance exception to the 50-50 rule? Who knows? It's there. The other one, and I'm not naming it, so y'all need to know, I'm not covering all of the exceptions under 209, just the ones that I think provide some tread for litigation or could be used to litigate with to avoid a 50-50 presumption. But you might have to overcome these if you want a 50-50 presumption. Is whether or not the parent has a chronic illness or other condition, epilepsy, or just nervous. Condition doesn't even say, it doesn't even mean, does it mean medical condition? Does it mean, a good healthy limp? I don't know. That renders him or her unable to provide care for the child. Does that particular statute fly in the face of American with Disabilities Act? I don't know. That might be a point of litigation. One that we hear all the time now is, does a parent have stable housing? Well, what does that mean? Does that mean it has a front porch and fire escapes and CO2 detectors? Or does that mean, you said to have every spick and span corner, all the dirt out? What does a stable mean? Is it a bad section of town? Is there some kind of an ethnic complaint that could be made? Let's hope not. But also the one here is that I'll see more and more of that. It says a parent who has avoided or refused involvement or not been significantly involved in a child's life prior to litigation unless prevented by the other parent. Now you talk about a trial within a trial. That could happen as a limiting factor on a 50-50 permanent parenting plan. Well, and what does significantly mean? Significantly involved in the child's life prior to litigation. Does that mean every other weekend? Does that mean once a quarter? What if you have somebody that works out of state and been providing, or has to travel a good bit? And then you get into litigation whether or not they've been prevented by the other parent. Well, that prevention, does that revolve around the child's medical condition? Does that revolve around domestic violence fears? This can be a fertile ground for attorney fees, and it can also be the bane of family court judges that will have to pass on these issues. The next one, I think, could be a new area for litigation as well under 209F. Everything I'm telling you is under subparagraph F of 209 until I tell you differently. Does a parent repeatedly leave a child with a third party as a ground for a deviation or to counter 50-50? Is it a limiting consideration? Well, does that include grandma and grandpa? Third party, does that include leave if you have to work during the summer, the child's out of school, and during your parent time, you have to leave a child with a babysitter? Is it worse for leaving it with boyfriend or girlfriend that the ex-wife or the ex-husband can't stand? And then it comes back and repeats under subparagraph F, a parent who has a third party living or regularly, what does that mean, at the parent's household has a criminal, domestic violence, or addiction record. Criminal or addiction, yeah, I can understand that. Domestic violence, well, people have been charged with domestic violence and it's been denied or dismissed, or it's been terminated, or it's been modified, or if the party that was the alleged victim comes in, or the proven victim comes in and wants to terminate it, how much weight do you give to the domestic violence in this? Again, the discretion of the family court judge, I think, has been reestablished. Lastly, we hear this all the time, is the parent's addicted to a controlled substance or alcohol. Now, the next batch are ones that I think has even a little bit more weight to them, and that is under 209F, the considerations. Just let me get over here on my notes to this. That is a 50-50 parenting plan impractical because of the distance or cost between the parents' home, the cost of transporting the child. Now, the distance between the parents' home, presumably that's the distance the child's going to be transported on a go-fetch parenting plan, permanent parenting plan. If it's midway, it loses a little bit of its vitality, I think. But then also the cost of transporting a child. Well, I don't have a car. I'm on unemployment, and this gas is really high, even though it's come down. And they're blaming the Biden gas increases or something of that nature. But that, I think most of us can really see through whether or not that is a legitimate. But then the one that is, I think, offering some degree of threat to either overcoming a 50-50 or not overcoming a 50-50 parenting plan is the child and, not the child's, the child and, a conjunction there, part of speech, each parent's daily schedules. Okay, well, this is going to be hard on my child. We have to transport him. Plus, I have to be at work at 7 o'clock. We shouldn't have a 50-50. Yeah, okay. Also disruptive of a child's education and contrary to the 14-year-old's reasonable preference. Now, I hear that a lot. You all hear a lot. You argue a lot. I don't think it's done anything to change the 14-year-old reasonable preference. I think all that law and all those statutes, including on the modification, is still intact. That means that if it's 14, it's, we give it some weight, but it's in my discretion as a judge to give it such weight as I think it deserves, and it has to be reasonably formed. There has to be a reason for it, other than the little girl wants to go and leave mom because mom won't let her date that little 21-year-old that just got out of Mount Olive prison. Or boy wants to leave dad because dad won't buy him a four-wheeler and he's going to go live with mom. The 14-year-old preference, and it's probably the best known provision, I swear to goodness, it's the best known provision in law in the state of West Virginia. I hear it all the time. You all have heard it all the time in litigation. Other judges have heard it. I'm 14 years old and I can go where I want to. Well, that's the best reason I ever heard for not giving him or her a preference. Next, and this one came in some form in 2018, but it came in a lot stronger in 2021, is whether the parents can work together and encourage a positive relationship between the child and the other parent. That one could stand by itself in defeating or allowing a permanent parenting plan under 209F. What really bothers me about these limiting factors as it applies to budding the 50-50 presumption is there's no real time constraint on adducing evidence in support of 50-50 or in support of more importantly, the rebuttals to 50-50. Remember old 206 used to be up to 2018. It used to be the 2-year look back period. That went out in 2018, and it's also embodied in 2021, or it's not in there. Now, if there would be, looks to me like there would be some limitation on it, but right now you can go through the history of the child. Now, if a child's 3 or 4 or 5, 6, even 8, 9 years old, that may be doable. But look at the practical considerations of trying to go back on a child that may be 13 or greater. There's no time constraints whether the child's 1 year old or whether the child's 17 years old. There's no time constraints. And that's a serious flaw in the statute, both in sub F and the whole Senate Bill 463. Modifications in this particular context of 50-50 statute. The modification of the 401 or 402, well, 401, of course, has the qualifiers of being substantial change of circumstances that were unknown at the time of the original decree, not a reasonable contemplation of the parties at the time of the entry of the original decree. And 402, I think those modifications are still intact. But it appears to me by reading of the statute that all 209F limiting considerations in modification are tied to parents' remarriage or cohabitation. Now, any of y'all judges or family court practitioners or pro se parties looking at that might come back differently. But the occurrence of a worsening of a 209A factor that has tied with violence and crime and sexual offender and all that after a parenting plan has been ordered is ground for modification. That's new under 401D. In other words, the occurrence or worsening of a 209A, a little a in parentheses, factor only after a parenting plan has been ordered as grounds for the modification. But I still believe, unless we hear differently from the ICA, that the statute seems to back this up too, that the application of the 50-50 presumption is not available to modify parenting plans that were in existence prior to June 10 of 2022. That's under 603B. Now that came close to passing, and I'm not confident that this won't be the law in 2023, but we'll see. Right now it's not. Tax exemptions, that's usually most custody fights. I guess I'm a little bit sarcastic about negative. Most custody fights are tied into, and especially the 50-50 claim. There's a great misconception out there that 50-50 means I don't have to pay child support. Whoever the obligor is, whatever gender, whatever sex, I don't have to pay child support. It's 50-50. Okay. And for 50-50, that means we automatically share the exemption. Well, the sharing of exemptions changed in 2022, but many of you know just because it's 50-50, even prior to 2022, does not mean there's not, in every case, child support. There is. If you have a great disparity in income. I just had one today. Bursted a guy's bubble because he thought 50-50 meant no child support. Definitely. He ended up, I think, $430. He was not a happy camper, as they say. But at any rate, on the taxation dependency now is that if 50-50 has otherwise applied, and it's after June 10 of 2022, that I may, in my discretion, divide the exemption deductions on an annual basis under the new 602. I may do it. So that might be something that you might want to argue, or at least don't forget about it. But between child support that you hear, that misconception that they don't have to pay, or this tax exemption, what does that tell you? This is a news flash. A lot of the custody fights and the allocations are over money. That's the real motivator. I am cynical. Sorry about that. Now, which law controls since June 10 of 2022? If a case is filed before June 10 of 2022 and all evidence regarding custody, temporary or otherwise, have been taken, then the old standards apply. Isn't that true? That's what I told people in the other two, and there was my legal opinion, judicial opinion, and the other two presentations I did on this on September 23rd, and I think it was October 14th. Wrong. As of November 18, 2022, the ICA, erroneously, in my legal opinion, has found that the entry of the order controls, notwithstanding when the final hearing was, when all the evidence was taken, I'm going backwards, regressing it, and when it was filed or when there were other hearings taken. That is the case of Amanda C. versus Christopher P. 22 ICA 2 that was handed down by the ICA on the 18th day of November. It came out of Upshur County. Judge Jackson was a family court judge. And this didn't have a thing to do with the application of the law. It had to do with whether or not there was a conflict between two judges. Judge Jackson went ahead and had the hearing because the rule hadn't been complied with, plus she was having difficulty, as we often do with circuit judges, and when we have scheduling conflicts. The issue about which law applied was not litigated at the lower level in front of the family court judge. It was not presented on appeal by either one of the three attorneys that took this up and submitted to the ICA. What the family court judge had done was she'd had a hearing. There'd been a final hearing. It'd been filed on February of 21. There'd been one hearing in May of 21. The final hearing was on May 11 of 22. Okay, May 11, not June 9th, May 11. And the order, because we're waiting on an order from the attorney, was July 8th was when it was signed by Judge Jackson. The ICA ruled that the new law applied. And it was remanded back down to her, or whether it's going to be Judge Turner, I don't know, with direction saying you have to apply the new law in this particular custody case. Now, anybody in the Supreme Court has repeatedly said in family law cases and others that if the issue is not preserved at the lower level and not presented for appeal, or presented for appeal the first time, they don't hear it. They don't pass on it. The ICA said, not us. We don't care if it wasn't an issue below. We don't care if it wasn't dealt with in the order. We don't care if it wasn't raised on appeal. We don't care if it wasn't argued in front of the presentation on November 10 of 2022. This is the rule of law. Now, if any of you out there have any cases involving this, that the order was entered after June 10 of 2022, and it's not in 30 days for the appellate period under the rules of appellate procedure haven't passed, you might be in for a rude awakening. Or if you didn't like an order, and pursue that as a point of appeal. Right now, that's the law. And to my knowledge, when I checked on it yesterday, it hasn't been taken up to the Supreme Court yet. Another scenario, if a case has been filed before June 10, 2022, and no evidence has been taken on anything, then the new standards, I think, obviously apply. But now, in the face of the Amanda C. case, definitely it applies. If the case is filed before June 10 of 22 and evidence on other issues taken except custody, temporary or otherwise, I took position you could flip a coin. I think in view of the Amanda C. case now, the new statute, the 50-50, applies. And notwithstanding all that judicial time that's already been expended on hearings and lawyers that structured their case strategically and tactically on the old law, now you got to go back and try it again. Is that going to cost people money? Yeah, I think so. Wish the ICA would have thought about this. My experience has been, and I hope you all can draw from this, we've got about 2 minutes left, and I find that most practitioners who come in front of me are unaware of the new 50-50 law in all of its permutations, that they are not familiar with what it takes to rebut it. And I think there's been possibly a noticeable increase in the amount of settled cases, but it's just because the practitioners think, well, it's going to be 50-50, let's just go ahead and settle the case. They don't have to. My prediction is going to be that there's going to be probably an uptick in domestic violence cases once a lot of pro se's know what, get some idea what the law is, have some semblance or notion of what the law is. I've always said to people know more about domestic violence and Social Security and unemployment to people that receive the benefits of it. But anyway, I think that's going to happen until if they understand the litigants about the limitations of 209. What I'm more fearful for than anything else, and even in some debate in the legislature when this came up, well, if we pass this 2022 50-50 bill, this Senate Bill 463, we're going to go back to pre-1986, where kids for cars were being traded off. In other words, you let me have the Corvette, as I said again, or the Ford F-150 truck, Super Glide, Lariat version, whatever, and I won't fight you for the kids. I think we're going to see that starting to happen. It won't happen in my courtroom if I can help it, and I'm not going to let any litigants do that. But who knows what this trade-off is going to be outside the courtroom between the parties. And then I think 209 probably will emerge as a larger looming prospect in custody modifications when parties have old orders but there's been remarried or commenced cohabitation, that there's some problems dealt with, because I told you I felt that the new 50/50 law would have a greater impact on 401 modifications. My conclusion is here that we're going to have a lot more evidentiary hearings at the long haul. There is some expense in the front part, the front loading of judicial determinations. I think discretions are going to suffer a little bit, so unnecessarily so. But I think that on the plus side of it, family law decisions are going to be a lot more solid and sacrosanct and not be overturned, because a lot of people they can't navigate. I'm talking about the pro se's especially, and even some lawyers are going to have difficulty navigating the new electronic filing. Now I know pro se's can go either they can do electronic filing or paper filing, but it's going to present a maze or a jungle for a lot of people that without attorneys can navigate. Plus, we're talking about these satellite offices. And I think at the Family Court Judges Association presentation, one of the ICA judges had said, well, they'd already dismissed some pro se cases because they didn't comply with the timelines. What's that mean in long haul? That means the family court judge decisions are going to be around, they're going to stick, are going to be viable, and they're not going to be overturned very much in the long run, numerically, I think, when all things are considered. But on the negative side of that, review by the ICA family court rulings is going to be left as a matter of reality and a matter of practicality, as a matter of economics. The people's got the money to litigate. So, as I said before, why don't we all go out there and look for limiting factors under sub F, limiting considerations? No, I jest. Anyway, if anybody's got any questions, I'll hang around. Jason, are you still with us?
Yep, I am here.
Gasp. If anybody's got any questions, I'll take them now, and I'll stay for at least another 15, 20, 30 minutes if necessary.
I have not seen any questions yet that have come through the chat. I don't know if anyone may have tried to send it to you privately.
Okay, let me come out of I'm going to hit stop sharing, Jason. That'll leave me on, but it'll take off the PowerPoint.
Correct. Now, do you see a little chat button somewhere?
I see up in the upper right-hand corner, it says Q&A.
There should be one around there that should say chat as well. Could be down in the lower right-hand corner.
Oh, I see it now. Yeah. Okay. All right, I'm clicking on everyone. This is everyone. I've got a chat box open. You may ask me questions if you want. There might not be anybody there, Jason. Everybody might have dove out about 12:30. Who knows? Lunch
Oh,
is
no. Trust me. It says there's still 116 online.
Is that right? They
We
just left
topped
their
out.
computers.
We had a wonderful audience today. We had topped out at over 130.
Wow. Wow. That means we've got 130 people cussing Judge Douglas from here on out. All right. I'm writing here something coming in that says from, well, I won't say it, who it's from. It says, great presentation. Thank you for your pragmatism. Okay. I'm just going to say that's me.
Okay, hold on here, Judge.
More.
I got a question. It was sent to me privately. I'm going to send it to everyone so they can see what the question is. Do you see that question?
Well, I see two. All right, I see one says, Judge, in relation to when parents have 50/50 custody, can you advise or comment for order drafters to consider healthcare decision-making authority by either parent for mental health care for children? Well, I think is that should be addressed, assuming everyone's still online. I think that should be addressed, but the context on how it should be in the order is to be, if you're saying that 50/50 is being imposed on you by the judge, that there be a consideration in there that, or that's saying that the person that was against the 50/50, here is the healthcare reason why it should be something other than 50-50. And I think the statutes altogether contemplate that. So I think it should be in there. You should have in there that, for instance, mom was arguing that it shouldn't be 50-50 because she has to give insulin shots to the child on a regular schedule, and the father can't do that on a 50-50, and that schedule's during his parenting time. I'm looking here too. There it says here that was from you, Jason. The next one says from a private one says the box says the public chat box was disabled. Not by me. Is it disabled, Jason?
No, not that I know of. I'm receiving some questions. If they send them to me, I'll copy them and put them to you.
Well, I just got one here too from you. It says when a 50-50 order is entered and the later evidence shows it has become.
Well, that's the question. I'm gonna put in there
If
the
we're
rest.
talking, if it becomes to a position, it's not tenable. Oh, here it is. And later evidence shows that it become 50 mom, 45 dad's mom. Oh, well, I think absolutely under the 209F that would be grounds for modification. I mean, I think I would definitely argue that. Now, I do say, I see what you're saying. Whenever we talk about 50-50 and prior practices and how the involvement of mom or dad, it is limited to mom and dad. If the kid has been with grandma 25% of the time and dad 25% of the time and mom 50% of the time on prior allocations, or I'm talking about agreed to allocations. Dad can't tack on grandma's 25% to give himself 50 for that consideration about prior history. All right. But I still think that'd be grounds for modification, but it's tempered by what I said under 401 under the new statute, where the 401 modifications involving 50-50 have to do with third parties in the home. And, or it has to do with third parties and maybe having, I think you could argue that the third parties could be extended family members. Okay.
Looks like you have a couple more.
Okay, I'm looking. It says, I'm just doing what's here. It's showing, will that be a hot, I think that's under the other one. In your opinion, all right, I'm reading right now from what I'll call Lisa. In your opinion, can the decision-making portion of the temporary order be separately appealed from the physical custody part of the temporary order? In my opinion, legal opinion, 203F can be appealed, but it has to be appealed on someone didn't get 50-50, the interlocutory appeal. It has to be involved with something having to do with the some aspect of the temporary order. Now, if decision making is split off in the temporary, I think that could be appealed by either party. And any aspect of the temporary order that does not have full 50-50 both on decision making and on physical or custodial aspect of it is subject to the interlocutory appeal. The answer on that's yes. Does the remarriage always attribute income increased in, this is another question, I'm gonna put this from Annie. Does remarriage, I'm having a little bit of trouble reading it. Does remarriage always attribute increased income to the party? No, we don't take to now. I think with remarriage, you don't pick up that income. If somebody marries a Rockefeller and before they were on minimum wage, I don't think it makes any change to the, when we're talking about attributed income, to the child support computation. I don't think I can include that. The only third party under 481228 that we can include in my memory, and my memory might be faulty because sometimes I'm having trouble remembering my dog's name, is that it says in 228 that we can take into consideration the child's income if it makes a substantial impact on the household financially. So no, increased income of the other party, no. Look at 481228. Here's another one from Vanessa, and I know who this Vanessa is, and I haven't talked to you for a long time. I'm so glad to hear from you. If the court has extensive temporary hearing with evidence presented and no proffer, can that be taken on judicial notice at the final on only new information presented? Now, let me make sure I understand the question here. On temporary hearing, we got evidence presented and no proffer. Can that be taken on judicial notice at the final and only new information presented? I think from an evidentiary standpoint, it could be subject to the parties. I think it could be taken on judicial notice. This was what tested at the final. And only new information is presented unless it is shown at the final that that information was inaccurate, a concoction, a prevarication. For the pro se people, that means a flat out lie, or that it was inaccurate, negligently presented, or innocently presented and inaccurate. I think it could be taken on judicial notice, yes, and the new information presented. Now, I think also new information could be presented that would impeach the temporary hearing evidence if one party is still clinging to what was offered at the temporary hearing. I hope that answered your question, Vanessa. And again, so nice to hear from you. Who else do we have? Anything else?
No, I have nothing on this end right now. No new ones.
All right, let me stay for another. I'll stay to 20 after. It's 12 after now. On my watch, anyway.
Judge, I'm getting several questions about your presentation. Did you send that to Sarah yesterday by any chance, or?
I sent it this morning, and she said,
okay.
I got the automatic answer.
For those of you that are asking that question, we will be sending out the presentation as soon as we get the opportunity to. That way you have a copy of it.
And I did comment that there was one error that I'd had on. It had a 209A that should have had a parenthetical expression on it, the A, the little A, just so everybody knows. Much to the chagrin and surprise of many of you, I'm not perfect. Oh my God, here's a big one. Okay, let me look. You're welcome, Vanessa. Says, hi, Judge, can we speak about abuse and neglect? Okay, let me see what else it says. Now, normally, family court judges don't handle abuse and neglect, and we don't handle adoptions. Let me read it. Hang on. Hi, Judge, can we speak about abuse and neglect? Suppose there's a case involving reunification of a child with non-cohabiting parents. I hear Rule 6 raising its head. The West Supreme Court has admonished circuit court judges to apply the factors listed in the Code 6, 7, and 9 when deciding custodial decision-making responsibilities. Those statutes utilize a preponderance of the evidence standard, although there is some contradiction. But the standard proof in abuse and neglect case is clear and convincing evidence. Now, if abuse and neglect is factored in to clear and convincing, and assuming the kids have come back to, for the purpose of this question, if there's been a reunification of a child with non-cohabiting parents, that comes back to the family court under Rule 6. I'm sure you all know the rule I'm talking about. Hang on here just to pull it back up. Well, I've got it tabbed. Hang with me. Hang with me. Trying to see it. I've forgotten. I've got so many tabs here on this book. I was going to read it. It comes back to the family court if there has been an order entered that finds a failure to state a claim, or that the child is returned to the cohabiting parents. Returning to the non-cohabiting parents, it stays with the circuit court. All right? Everybody still with me on that? Wait just a second, Jason. Got something else I want to say about that. With me.
Judge, while you're looking for that, the next two comments that I forwarded in there, it's just a continuation of that question.
That same question?
Yes.
Okay. If a child's returned to the non-cohabiting parents, then to me, that stays if there's been an abuse and neglect and it's returned to the non-cohabiting parents, then it still stays in the circuit court for all purposes. And if those statutes have a preponderance of evidence and there's been an abuse and neglect, and let's say there was an improvement period and they were sent back to the kid, sent back to the parents, they successfully had an improvement period, then any changes with a parenting plan subsequently, in my view, it goes back to the circuit court. I'm looking here. This is from Annie. Are interlocutory still to the circuit court? No. All interlocutory under 207 subparagraph F under the new 50/50 statute under Senate Bill 463 or the Best Interests of the Child Act go to the ICA and nobody else. Now that we're talking about ones that after interlocutory orders after June 10 of 2022, and considering that Amanda case, the ICA came out with, even if there was interlocutory pronounced before June 10 of 2022, and the order entered after it, it still goes to the ICA. The question was, I wonder which standards should apply. Well, if there is a subsequent, in my opinion, if there is a subsequent divorce between people that have been subject to an abuse and neglect, and it went back to the non-cohabiting parents, then in my opinion, it's still at the circuit court, and any of the limitation factors under 206, 207, or 209 are by preponderance of evidence standard. That's my opinion. I think all those follow-up questions are still the same. I'm not going to do anything else. I pull that statute, that rule up here, and know where it's at. It's just a way of getting closer. If there's some other questions, they can get it while I'm still looking to bring that up on my tab. Okay, it's family court. Are there any other questions there, Jason?
No, I don't have any at the moment.
This is the rules of procedure for child abuse and neglect passed by the Supreme Court. And there were two cases that were in front of Judge Van Meter. I think they were handed down on November 20th of 2019. There were two of them the same day. There were signed opinions that breathe vitality into this Rule 6 of the West Virginia Rules of Procedure Family Court. It says as follows, and I'm going to read this. It says, each child abuse and neglect proceeding shall be maintained on the circuit court's docket until permanent placement of the child has been achieved. The court retains exclusive jurisdiction over placement of the child while the case is pending, as well as over any subsequent request for modification, including but not limited to changes in permanent placement or visitation, except that one, if the petition is dismissed, as I said, for failure to state a claim under Chapter 49, or the child has been returned into the legal and physical custody of both of his or her cohabiting parents. Now, that's where it stays, but preponderance on a subsequent divorce or an allocation of some kind will be by preponderance of evidence in my legal judgment. Okay. Now, what's the other questions, Jason? Is more coming?
I don't have any more right now.
Let me stay on for another 5 minutes. Do you have something you got to do, Jason?
I am good.
Okay. Let's stay on to 25 after anyway. I'm still here. I'm at everybody's disposal. But those materials will be available. I know that Sarah told me if I got them in this morning, she'd get them out. So evidently she must have had some other emergency.
Yeah, she has. She's out. She had to go take care of some things.
Okay. Well, that happens to all of us. But I couldn't find that Rule 6 because the tab came off. Okay. There's also a very similar rule. It's called Rule 13 in, if anybody's still on there, Rule 13 in the domestic. Second. Find it. Just a second. I'm coming up on that one too. I know exactly where that one's at. If you look at Rule 13 of the West Virginia Rules of Procedure for Minor Guardianship Proceedings, same thing is that once removed under usually a 48A referral, 48A means allegations in effect somebody has been sexually abused, a child, and you send it up under Rule 48 to circuit court. Once removed, it stays up there for life. Life. It says it shall not be remanded to the family court. And I think too, if you have domestic violence action, too, that there's been prior activity by a circuit court on, I think that's where it should go because there is concurrent jurisdiction under domestic violence statute. I think it's, don't I have to look it up, 4827-301 is what I'm going to say. Hope that's accurate. 4827-201, 301 I'm talking about. Hope I'm right. Yep, I'm right on that. Circuit courts have, and family courts and magistrate courts have concurrent jurisdiction on domestic violence proceedings. And I think definitely want to allocate back to a circuit court that had an abuse and neglect. Because I don't think the family court has jurisdiction on that. That's just me. So I'm sure I'll get plenty of hate mail from maybe circuit judges on that if they see this. Any other questions? I got 2 minutes left.
Nope, I don't have anything.
Let's give them the 2 minutes in case somebody's typing. Hasn't hit the enter button yet. Now, Jason, tell me the truth. How was the presentation?
I thought it went well.
Whoops. Somebody telling me, Annie, you were great. Thanks. I appreciate that, Annie. Annie must have heard I was single. I'm joking. I'm joking. Thank you, Annie. I appreciate that. A guy gets to be my age, we need all of the compliments we can get because God knows all the hair's gone off the top of my head.
I had someone else just comment to me that it was very interesting.
Mark told me it was eye-opening. I don't know whether that's good or not. Very interesting. Is that a substitute for very good?
I don't know.
If anybody's still on there, just a parting word. Please, please, please read that statute. And don't be quick to agree that there's equal caretaking functions in custodial allocations and not have an eye toward decision making. That's where a lot of people are going to get caught, and attorneys could be charged with malpractice, I think, if they're not aware of that 207. That 207 trigger, I call it, where 50-50 has to be triggered, number one, and then number two, it has to be, it can be different than the custodial allocation. You could have 50-50 on the custodial allocation and something other than 50-50 on the decision making. I'm gonna see another one here. I see here one from anonymous person says, you just said, Jason. I says, I just received this one. Thanks to God for judges who have actually practiced domestic law. Well, I definitely qualify on that. And across the state, there's not very many of us, to be honest about it. You'll know, practitioners know when they get in the hearing room, which judges have had experience and which haven't. I mean, in this, what Judge Kidd, I clerked for Judge Kidd, William Kidd, from Braxton County originally, and then went on to be United States District Court judge. He said there's no teacher like being in the snake pit. That's what he referred to as litigation. Somebody's actually practiced the law. If you've been in the snake pit, you got a big advantage when you're sitting in this with the black robes and the big chair.
I think that about wraps it up, Judge.
I've got 25 after.
That's what I got.
I actually got 27 after. I think it's freaking batteries off. Okay, well, I'm gonna go down there and hit the red X. Jace, thanks for your participation. Thanks for your kind words and thanks for your cooperation and your mentorship on, this was my first teaching webinar, so now I know what to do. Appreciate you.
Thank you very much, Judge.
Hidden, and you can pass it on to your superiors up there, which they're probably not any superior to your knowledge. I better be honest about it, that Judge Douglas is very pleased with your cooperation and your contribution. See you later.
See you later.